One.
Good day, everybody. Sam Shihab with the law firm of Shihab Burke.
Brian Burke from Shihab Burke here Monday at 6 p.m.
Excited?
Not Monday at 6 p.m.
Wednesday.
Wednesday at 6 p.m. We did it only on Monday at 6 p.m. for so long, I'm stuck in that mode.
We have been working hard on H1B cap cases, and we're a little bit tired, but we're going to answer all your questions today. We got some questions here that came in, and we're going to take questions posted live as they come in, when they come in, and we will then start with our questions here.
Well, before, Sam, you start with our other questions, I want to make my commentary as to where those questions come from. I think they come from a website called immigrationquestions.us. Immigrationquestions.us is our fun little website where you can go to anytime, any day of the week and send questions to us, and we'll answer them live here. And isn't that fun?
Yes.
So speaking of, I know you have some from there, and I'm going to try getting some up on the screen, but what do you have, Sam?
All right, so sounds good. So this is an interesting question. So this first gentleman says, I am on an H1B visa and have received multiple job offers. And working with the companies, I am negotiating with multiple companies to get transferred to. And I understand that these companies are filing change of status H1Bs a few days apart. What happens with multiple employers file multiple change of status petition for me few days apart?
So this is somebody who is F1. I'm probably on F1 right now,
No, this guy is on H1B.
But it's
a transfer. Well, the change of status. Yeah, he's on F1. Correct.
Oh, sorry. Okay, change of status.
Yeah.
Okay, so changing from F1 status to, and right now you're on F1 status, and then you get selected in the lottery, and if you get registered through multiple companies, 4 companies, and you get selected once, you get selected with all 4.
Yeah.
And
now they're doing change of status, and he's not telling.
Yeah.
Which number one is a massive waste of the client of the employer's money.
Yeah.
I guess legally you're entitled to it, but slight abuse maybe. But be that as it may, it's your prerogative. It's legal. We don't pass judgment. And the answer is very simple. You're going to get multiple approvals, assuming all of them are legitimate cases, and you're going to have potentially receive multiple I-94s.
Yeah.
And the one that you choose to work with is the one will end up being the I-94 that attaches to you, and the ones that you do not choose to work for, the employer will probably withdraw these H-1Bs as soon as possible, because their counsel will recommend that they do that because of the legal exposure of having an approved I-94 without a paycheck. And then you move on to the company you choose, and every employer that you have not joined is out the filing fee and the attorney fee. So that's the answer to this question. Do you want to add anything to it, Brian?
No, I think you've covered it pretty well. I mean, I think the fundamental question for that person is, do they expose themselves to any liability there, personally, obviously? And I think the answer is not very likely, unless you're entering into some sort of, opposite that side of immigration, but employment contracts where you promise to do X, Y, Z for company A, and you don't because you're doing it for company B and C.
I can assume that that person can find a very good lawyer that would be able to argue that person out of these because of the H1B rules and regulations. I mean, you cannot really coerce somebody into employment when that person does not want to be employed with the company.
Sure.
It is really an employee favored process.
Yeah.
The employer is out, and that's the only thing I would say to that is that's one of the reasons that some companies do not want to file H1Bs is because all they have to do is get zapped one time, and the filing fee is steep anymore.
Yeah,
especially if you do premium processing.
Bigger companies, so you got $780, $600, $500 for initial filing, and then $1,500 probably. That's a good chunk of money right there.
Premium processing.
Yeah, adding premium processing. Yeah.
And that's a lot of money. So all what they have to do is get zapped one time, and if they're zapped one time, they're not going to do this for a while again. Yeah. So that's the only thing I would have about this. All right, sounds good. Do you have one, Brian?
Yeah, I'm gonna.
So let me jump into the next one as we keep things going here. This gentleman wants to know, how can I calculate the earliest date to apply for naturalization? And then he throw in the wrench on us. He says, I have one trip outside the U.S. for more than 6 months during COVID and was unable to return in a timely manner. So there's two different questions.
Got it up there on the screen for us there, yeah.
Okay, good. Oh, wonderful.
Yeah.
So two issues here. One a little bit complicated maybe, and the other one is simple. So how to calculate that is if you are not applying based on a marriage to a U.S. citizen, and you're not waived in down to 3 years from 5 years, you must apply for naturalization 90 days prior to the 5th year anniversary of your green card. And how do you calculate the 5th year anniversary of your green card? Is by looking at your card and it says resident since date. And that date, you go in and you move that last digit of the year 5 years forward, and that would be the 5th year. And then you move it back 90 days.
Yeah.
And that's the earliest date you can file for naturalization. It's very simple. Now, there are specific rules that would vary that a little bit. We're not going to get into some of the exceptions, but these are the general rules. Now, this gentleman was outside the United States for COVID, Brian, for more than 6 months. Couldn't fly back to the U.S. It was a very common issue.
Sure.
I think that's be overcome by providing an explanation
of ties to the United States.
Well, ties and the exceptional circumstances that led to his inability to return. And normally what they look for is ties to the U.S. For example, you kept your bank account, you kept communicating with your employer, you still had the same job, you still had your car. Maybe you had a house that you kept making payments on. Maybe you had other relatives here in the U.S. The relative is a big deal of it. Ties to the United States, familial ties, family ties in the U.S. All these things goes into assuming that the departure for more than 6 months did not disrupt the continuity of residence here in the U.S. But you want to put a very solid documentation. This is not something to be taken lightly. You need to kind of stack it up with as much documentation as you have. Now, you sold your house, you sold your car, you shut down your bank account.
Got some problems.
And got stuck for COVID. You have a weaker and lost your job or resigned. You have a problem. You have to come back, and then obviously maybe a green card problem potentially as well. So consult with an attorney. This is a kind of a delicate case, and you want to make sure that this is done through a very careful analysis. All right, sounds good.
I'm managing to, while you're talking there, Sam, get some of these things extracted from immigrationquestions.us, and I'll get them up here on the screen right now.
Yeah.
So, here's a fun one. Any update on the Trump card visa? The Donald Trump's proposed $5 million and will give you a green card sort of visa. And the big news story in that subject was there's a website that's been launched that's an interest page. Put your name on a mailing list to register your interest. Now, I, of course, where my brain instantly goes, and Sam, your mic is, okay, there you go. Okay. I want to go to that website to see if there's any requirements, any sort of parts of it kind of set out there, and there's nothing. And, having thought about that Trump card visa, the, $5 million gets you a green card. The spot my immigration attorney brain immediately goes is, don't they need to pass a law to do that? And the answer is yes.
Oh, absolutely.
Yeah. And I guess, Sam, I'll ask this question to you. I guess the short answer on the update on the Trump card is no progress yet, just a lot of talk. But Sam, do you see that happening?
I see not. I don't see it happening. Let me tell you why. So the Golden Visa program in other countries are being shut down.
Yeah.
And part of the problem is they have had problems with it. And not only that, but the U.S. Well, so which one's it? Cyprus, Golden Visa program, shut down a few years ago. Spain this year shut it down. And Ireland shut it down a couple of years ago, and other countries. Now, it does exist here and there. Like Malta has a program. Now, Ireland has a permanent residency program that can become a green card with residency and physical presence program. So the U.S. also, in their travel ban, part 2 that has leaked, that is not official, adding another 30 countries potentially to the ban, which we can discuss later, but this is news, not law right now, has also listed countries that issue, Caribbean countries that issue...
Yeah, you mentioned this to me, yeah.
The golden visa by paying money only as a country that they are going to blacklist potentially. So it is frowned upon worldwide because it's causing problems. The U.S. might have a program that is going to have to be a lot more hunkered down program with a lot of requirement of physical presence. So it's a complicated deal.
It's a great headline, but a complicated deal.
It's a complicated deal, and it definitely requires congressional act. It is not something that the executive branch can create on their own, and the administration of it has to be created. So, yeah, I don't see it.
Yeah, when I think about this, I think to myself, okay, they have to draft an entire law and create policies and basically have some sort of criteria attached to it, because clearly it's not just going to be deposit $5 million, green card, we're done. At least I don't think it will be, but who knows? But and I think about when you start adding in requirements, I can only imagine it's sort of starting to look a lot like the EB-5 program that we have. You know, the EB-5 program, for those who aren't aware, it's not just, you know, $1 million or $1,800,000. It's, you know, to create a business, to create jobs for U.S. workers. I imagine there has to be some sort of, you know, something else beyond just deposit money, right? And when I think about that, I think what seems
some countries have like donation. We will take donation for that kind of money. But who has?
Well, this is America, Sam. We got requirements here.
Who has that kind of money to just hand money donation? These are the kind of people that maybe get their money too easy, which is maybe not the kind of money we want to have.
Part of the concern there, but I just imagine, like, the thing that seems more likely to me is some sort of reform in the EB-5 program, where it, in fact, and just raising the amount of money for that, because I've said this in the past. You know, the EB-5 program is $1 million. When it started, it was essentially slightly lower, but it's still essentially $1 million. And what is $1 million? A lot less than it used to be. Essentially, it's more accessible. There are no doubt people in our audience right now with $1 million houses.
Yep.
You know.
All right. Any questions from our audience, or shall we keep going with immigration questions?
There's.
All right. So let's jump in here and take care of those guys.
Yeah. From Tech Topics, my compelling circumstances EAD is expiring in January 2026. If I file renewal of this EAD in December 2025, can I stay in the U.S. while my current EAD is expired and my renewal application is pending? So,
excellent question.
Yeah.
Excellent question. So the compelling, I mean, obviously, if it's pending, you can stay pending the decision. Now, there's two things. Can I stay? And
I'm not even sure about that. I mean, I would presume so, but yeah.
I would say if there's a pending application, I think you can stay until the decision is made. But the next question I have is, is there an automatic extension of that EAD, or you stop working?
Yeah.
So we have to look into the automatic extension EAD and see if that category is
one of those categories. Yeah.
And offhand, I can't tell. I don't remember.
Yeah.
And then clearly, if you cannot work, you have to wait until a decision is made, and if the decision is not made, you have to leave, because it doesn't convert to a different status.
Yeah, I'm wishing you luck, Tech Topics, on your renewal of your compelling circumstances EAD. One of the things that worries me about that program is I looked into the numbers on the compelling circumstances EAD program. It's that they didn't take many applications, and there weren't very many extensions that were being approved. And the thing that sort of worries me is that one of the YouTube topics we had in the past, I'm not trying to be a gray cloud, but one of the YouTube topics we had in the past was they put out a really liberal policy during the Biden administration, compelling circumstances EADs. They said if you own a home and have kids in school, and I can't remember what the last sort of thing in their example was, that looks like compelling circumstances to us. Meaning that's one a lot of people could make. So
right, and that's still on the books. But I wonder if this administration would even look at that.
Yeah, I mean, that's the question. Right, there's a question right there. It's compelling circumstances EAD. A question from Runyon about that.
Yeah. Well, Runyon, you just answered his question.
Yeah.
All right. So taking on the next one here from Igonazo Mali.
Igonazo Mali. Yeah.
I'm seeking a job portability. My title is the same and duties very similar. The salary is big bump, about double. Okay.
There you go. And part two.
And also the field in your also some field. What that mean? I don't know.
Oh, it's the same field.
Same field. Oh, same field. Okay. In your experience, do job portability see a lot of denials, and what this current administration? Thank you. So that's a great question. Job portability in general has been liberally received. That would be a general statement. There is a policy guideline that was published about it that really put together a very predictable path on what is and what is not a job portability.
Yeah.
And if you can, Brian's trying to look at it here for us online as we're talking. But ultimately, it begins with the job description. And it begins with how the job description describes the work. And if the work is similar or the same, and you have to identify a job, Department of Labor job code to that job, and if the codes are the same, you're in luck. But also, if the code is a natural progression, different maybe, you moved into maybe a little bit more managerial role, it's a natural progression to the job that you had before, then that's also acceptable per the policy. Obviously, the devil is in the details, but I'm talking in generality. And then furthermore, with the bump in salary that you're talking about, there could be a good explanation. Number one, moving up, you have more experience. Number two, a different location. Maybe you were in Iowa and you moved into Seattle. Just example. The salary is a lot higher in the West Coast, and the experience level is more. So that does not bother me too much.
Yeah, I'm going to kindly put a link to the USCIS policy manual's chapter on portability. And I often find the USCIS policy manual isn't particularly readable. I think this is a pretty readable chapter, and I think it's the sort of thing where Ignazo, you can feel a little bit calmer after reading that. Now, you are at the point where it sounds like you are just kind of getting into a new job, and you know what your old job says on your, if you're thinking about the duties, you have some control as to what your new I-45J looks like. I mean, you can really work with your employer and let's try to fit.
You do need a supplement J.
Yeah.
And you do need the employer to sign off on supplement J, so that's something you want to do. And also, normally what I engage when somebody tells me it's a big jump in salary, I engage into what were you doing there? Who is the company? Sometimes you're working for a small startup or something that's a small salary, and then now you're working for a national company.
Yeah.
And then they pay more, and maybe the job has some travel in it, or the job has a little bit more responsibilities, but maybe it's at 20% more, but it's more.
Yeah, it can go the other way. Go the other way too. I mean, if you go from startup where they throw money at you to public sector because you're a nice person and you want to do that, you can literally deal with a salary going downward, and it's not necessarily a killer.
Yeah.
They don't look at just one factor. Yeah. So there you go.
Absolutely. Yeah. All right, sounds good. Well, thank you guys for asking those questions. We'll jump to immigrationquestions.us and keep the questions coming.
Yes, sir.
Don't be shy. But here's a good one. This is a good one. Can I work? I don't know if you found it.
Yeah, I got it up there. Yep.
Can I work for a U.S. company on H1B while being outside the U.S. but get paid in the U.S.? Well, I think the premise of the question is problematic.
Yeah, it makes my head hurt a little bit. So maybe we pull apart.
Yeah.
So maybe if you're, I'm gonna maybe answer a question. If you are outside the United States, you are not on H1B status, right?
You're not on any status.
You're not as far as the U.S. is concerned. Agreed.
Yeah.
So, okay. So I'm going to remove the while on H1B. So can I work for a U.S. company being outside the United States but getting paid in the U.S.? That's if you remove the status question, and my answer is yes. A U.S. company, you are outside the United States. A U.S. company can pay you to do whatever they want you to when you're abroad. And
what's the advantage for that?
Well, if you are outside of the United States, you are generally not subject to the labor laws of the United States.
What would you pay Social Security? What would you pay?
Okay. So maybe you're saying, Brian, this guy is outside the United States, not in this country, and they're paying Social Security taxes, local income taxes. Why would you want that? And that's a compelling point.
Yeah,
for sure.
There are other issues that are more compelling than immigration that needs to be looked at. Number one, can a U.S. company employ someone on payroll while that person is outside the U.S.? It's going to be subject to the other country rules and regulation and laws.
Yeah, this is very true. I mean, my next question is, well, are you going to be breaking the rules of whatever country you're in?
Yeah. Let's say you're in Canada on a visitor visa, and now you're doing work. Maybe you're breaking Canadian immigration laws. That's not a problem for the U.S. company. That's a problem for you.
Yeah.
You're the one doing the work.
Yeah.
So you have to also look at U.S. laws. Foreign laws in terms of where you at and what's your employment.
Yeah. Well, Sam, this question has, and maybe you speaking about it has brought something to my mind that I don't think we've ever talked about in this venue, and maybe it's not perfect for this audience, but it's the person who comes to the United States on a visa that doesn't allow work, and they're working for, they're physically present inside the United States on a visa that doesn't allow work, and they're working for a company outside the United States. And is that lawful? And a lot of people seem to think it is. But it isn't, and
it's a completely different question.
Yeah, it's kind of the inverse of it. Yeah.
Yeah. So can I be here in the United States on a student visa, or here in the United States on a visitor visa, and I'm performing services to a company
outside? Yeah.
Yeah, and that's a problem, very big problem. As a matter of fact, a lot of companies make the mistake. So we have a client who came into the United States for the purpose of meetings with clients.
Yep.
But they had meetings spread out. So they had 3 meetings, one to say in March, one is in April, one in June, in the US, big important meetings. And those meetings are perfectly okay according to
meetings are classic B visitor business stuff.
But that client stayed in the US in between and continued to kind of prepare for the meeting, but also communicate. And it sounds like a little bit of a problem to me.
Yeah, I mean, it
sounds like it to me, right?
If basically, well, yeah, so I'll fill in the blanks, you have a meeting in March and a meeting in April. Those are a 1-day, 3-day meeting. What are you doing between March and April? Are you still doing your job? Well, I'm, working remotely. That's how people get pinched at the border by customs,
And people don't know that. They do not know that, and that's a problem.
I mean, literally, I think if ICE were to camp near the Disney World, and just monitor the Wi-Fi communications, they'd find lots of people, while family's at the park, I'm going to just stay here at work. That can break the rules.
One of the questions, really, really a good question. Is I don't know if you have it on there.
Yeah.
Would filing an I-140 non-premium processing help my CSPA status of my 20-year-old daughter? Please explain. So that's somebody who probably knows the answer that asked the question, or maybe suspects and wants confirmation.
Yeah, and
this is huge, right?
Yeah.
This is the most overlooked aspect of the non-premium processing benefit.
Yeah. So
answer yes or no.
So will filing an I-140 non-premium processing help the CSPA status of my 20-year-old daughter? Please explain. The answer is yes. Significantly. So everybody loves premium processing. Nobody likes to wait. Everybody likes a quick decision. But in a CSPA scenario, you want your I-140 to be in process for a greater amount of time. The bottom line is the time the I-140 is in process, your child essentially gets that artificially added to their age under the Child Status Protection Act. It's a big old complicated analysis there, but long processing I-140s are better. When we were doing a lot of second I-140s for people a while back, oh, my EB3 date's ahead, I wanted to file another I-140 and EB3. Part of the conversation there is, okay, happy to do it for you, but if you file this in premium processing and if you change the basis of your I-140, it can change the CSPA calculations for your child, and you have to worry about that a bit. Or at least I do.
You lose time, right?
Yeah.
So the moment the I-140 is approved, the clock starts ticking again for your child.
Yeah.
When the I-140 is filed, the clock aging your child, let's imagine you're in an artificial world in which age can stop.
Yeah.
Once you file the I-140, if your child is 20 years old and 6 months and 1 day, that child remains 20 years old, 6 months and 1 day when you file the I-140, and then when the I-140 is approved, the clock starts ticking, becomes day number 2, day number 3. So the longer you stretch that I-140 review process, the more time you have to be able to keep your child under 21 legal or CSPA age. And if you have a priority date issue where you would wait to stretch that to be able to file the adjustment, that can be a lifesaver.
Yeah, I mean,
for your child.
Somewhere right.
It could be the difference between your child getting a green card and not getting a green card.
I mean, somebody out there right now is miserable. I'm going to just describe the perfect scenario. Somebody right there out there is miserable. Their I-140 has been denied. Some lawyer is out there working on a motion to reopen or appeal of some sort, and that nightmarish long I-140 is going to actually save their child's ability to immigrate, because it's going to take years to resolve.
Yeah.
That's the crazy thing. Yeah.
Yes, 100%.
Yeah.
Do you have another question, Brian?
Yeah.
Here we got one last one.
Yeah, and sort of a question is, any new trends in H1B RFEs? And this is a question I've heard a fair amount of times recently. And well, I guess one of them is because it's H1B cap season. A lot of people have been saying, what should I be worried about? But what have I been thinking about? We got new rules in January of 2020 for H1B. And a big part of that was that, hey, we definitely have power to request contracts, to make sure that, or contracts and documentation from the end client to make sure that the work that you're doing is a true H1B. We get to hear from the client. It's built into the regulations now. It was a big controversy that it wasn't. There was a big lawsuit on it. Now they have the power. I haven't seen a change in H1B RFE policy at all, really. No. It really seems to be same old, same old. And when I'm thinking back, the government deals in templates. The same H1B RFEs we get over and over and over and over again, and they're predictable, and this helps us out a little bit because our responses can be sort of catered and refined repeatedly to that. But the only new RFE H1B template that I've seen in the last couple of years was the one of, hey, we talked to somebody at the end client site, and you told us that the wages of this H1B should be level 2. We talked to somebody at the end client site, and they say the wages should be level 4. Help us reconcile that. But that's it.
Yeah, there's really, I think people there's more fear and nervousness than there is, in fact, a problem with the H1B program. All right, sounds good. So we got room for one more question.
Yeah.
Do you have anything for us, Brian? Here, I got one good question here, but if you want,
we have a live one that's I think worth talking about.
Can you please share insight on the approval rate of self H1B? Honestly, we have not seen a lot of self H1Bs.
Yeah.
And the reason we have not seen a lot of self H1Bs is because there is a practical problem. As a matter of fact, we may be into a self H1B here soon. There's a practical problem between the time this self H1B was approved and enacted and the lottery timeline.
Sure.
For self-applicants to create a company, make it viable, make it ready, and then file for an H1B. But I do have a client who, interestingly, has a patent in their name, and the patent is really what the company is driving. It's driving the whole company, and he's hired in with a oversight. is definitely looking at that scenario on a concurrent H1B for a different company, also for a different patent and a different product that he's working on.
That seems like a pretty good scenario. I like that scenario.
Yeah, but we haven't seen it to really comment on it too much.
Yeah, I mean, I would say, and I just sort of have my thoughts as to why here. Imagine it's really hard to set that up, and the H1Bs are complicated. We do them routinely around here, but H1Bs are complicated. Just getting the company to a spot where you can properly support an H1B employee is a challenge. And I think for a lot of these hypothetical H1B self-employment scenarios, there may be another visa or another option that's just better than it. And that's that.
On a case-by-case basis.
On a case-by-case basis, for sure, yeah.
All right, sounds good. Well, thank you guys for listening to us. Hopefully the Q&A session is helpful. Bring your questions. We'll talk 6 o'clock Eastern Time, Monday, to take more questions. And